Hello, and thank you for joining us on Ask Andrew, Canada's first Facebook Live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the managing partner here at Feldstein Family Law Group, and our firm has offices throughout the Greater Toronto area. I practice exclusively in family law, and so do the lawyers in my office. Now, today our special guest is employment law lawyer and mediator Stuart Rudner, and we'll be discussing the impact of divorce on employment law. And please feel free to ask questions in the comments section on Facebook Live or send us a text message, and we'll be able to hopefully deal with your question during the show. Welcome to the show, Stuart.
Thanks for having me on Ask Andrew, Andrew. Looking forward to it.
My pleasure. You're the first person to do the double Ask Andrew, Andrew.
And I said it clearly, which I'm very happy about.
Okay, so the first question, and we have some questions that came in before the show started, and the first one was from Twitter. I have shared custody of my son, and on the days that I have him, I need to go into work a bit later. My bosses refuse to allow me to do so. What can I do?
Yeah, it's an interesting question, and it's one we're seeing a lot more of in recent years. And there was a case about 3 or 4 years ago now, handed down by the Federal Court of Appeal, which confirmed that the Human Rights Code, which protects family status, is one of the protected grounds, in addition to things like race, religion, gender, etc. Family status is a protected ground. The court confirmed that that includes things like childcare obligations. So in other words, employers have to accommodate childcare obligations to the point of undue hardship, which we could spend 20 minutes talking about in and of itself. So I won't go too far into that. But the point is that after that decision came out, a lot of employers panicked and thought, we have to let everybody who's got a kid dictate their own hours. And that's not at all the case. In order for this, I was going to say caller, but the person who asked the question to get the accommodation that she says she needs, she's going to have to show an actual need. In other words, not just a preference, not that she just wants to be there to take her kids to school or pick them up, but there's no other way to live up to her obligations to look after her children without either coming into work late or leaving early or whatever the case may be. If she can show that there is no other way that this can be accommodated, then the obligation falls to her employer to say either, yes, we can accommodate, or no, we can't. But it can't just be a knee-jerk reaction. The employer, and we work with a lot of our employer clients who are faced with any type of accommodation request, they've got to document what they went through in order to assess if it's possible. And if they say no, they're going to have to be prepared to explain why it's going to cause undue hardship. In other words, substantial cost or interference with them carrying out their business, and therefore they can't do it. So I guess the short answer to the question is you may be entitled to accommodation. You're going to have to prove there is a need, and then the onus falls on the employer to show either that they can accommodate or show why they can't.
It's actually an interesting issue, because I once had a friend of mine who was an employer, and the receptionist made that kind of accommodation request 5 or 6 years ago, saying, can I come in at 9:15 because I'm uncomfortable with my 10-year-old son having to cross the road to get the bus on a major street. And the employer said, fine, and let it ride. And the employee kept on coming in 15 minutes late. Then 6 years later, the employer went to the employee and said, well, we're a little confused why your now 16-year-old son needs help crossing the road in the morning to get the bus. So it's a kind of thing, I mean, I'm not an employment law lawyer, but the employee and the employer have to remember that the need and accommodation that may exist with a 6-year-old, a 10-year-old may not always be there, because as the child matures, that need isn't there.
Yeah, it's just like a medical accommodation. If you say you've got a bad back and you can't lift heavy weights, and your doctor provides evidence saying that's going to last for 3 months, or your doctor is just silent on the issue, presumably 6 or 7 years later, that issue has changed. So you can, as an employer, you can reassess. Case about a year ago with an employer client of ours, where they received one of these requests, where their female employee said, I can't come into work before 9:30 because my child's daycare only opens at 8:30. By the time I get downtown, it's going to be 9:30. The problem was this was in Toronto, and there are lots of daycare options in Toronto. And all she could say was this was the daycare that she preferred. She could not prove that it was a necessity that her child go there. So as a result, there was no real need for accommodation. So I talk about this a lot, and in the context of disability accommodation, in childcare obligation, medical marijuana is a big thing lately. but it's got to be a dialogue. It can't just be a one-off, I need to come in later because my kid goes to daycare. There's going to have to be evidence. And then once the evidence is there from the employee, the employer is going to have to assess the evidence and provide their own evidence as to whether they can accommodate or not. It's got to be an ongoing dialogue. It's not a one-off conversation.
Okay, now I see we have a question from Facebook Live from Ivana. Husband owns a small business and I work for him. We are separating and he is threatening to fire me. Do I have recourse? I'll let you start with that, Stuart, and then I'll give my family law perspective to it.
Yeah, sounds good. And it's interesting you say that because I've got a situation like that going on right now. And in that case, the husband and wife were both shareholders in the company and they split. And ultimately, the husband turned all the other shareholders against her and they ousted her. So she's got a corporate claim, she's got an employment claim, and of course, the family claim all going at the same time, just to make things interesting. But I'll comment on the employment law side of things. As I mentioned a few minutes ago, our human rights code in Ontario, and it's similar across the country, protects family status. So you cannot be fired, you cannot be overlooked when you're applying for a job because of the fact that you're married, that you have kids, that you're divorced, etc. Similarly, if you're being ousted simply because you've now split from your husband, that's discrimination on the basis of family status. So you may well have a human rights claim to make in addition to your wrongful dismissal claim.
Now, from a family law perspective, I look at it very differently than you do. And here's the interesting twist is, let's say the husband is the sole owner of the business and the wife has worked for that person for 15 years and has what would arguably be significant termination pay owing to her. From a family law perspective, we would argue that the termination was an obvious result of the breakdown of the marriage. And therefore, if there was any termination pay owing, it's clear that that would be a liability of the business and in turn would reduce the value of the business on the date of separation. And we would argue that the wife would have a corresponding asset on the date of separation, being her entitlement to the termination package. And that really means at the end of the day, there isn't any net gain because it's going to be all impacted in equalization or support. So quite frequently when I have clients come in and they're really concerned about the employment law issue as it relates to their former spouse, the practical reality is the former spouse is getting their share of the business indirectly through equalization. And now that they lost their job and may struggle to find work, they're going to have a valid claim for spousal support. So it's really picked up in different areas because if you get a termination pay and it was after the date of separation from your former spouse, they're now going to be able to say, aha, you have an income stream. It's going to impact what my spousal support is. So they really are all interconnected and it becomes the practical reality of how much does someone want to pay on legal fees. Now, in your scenario that you're talking about where there's an employment law, there's a corporate law, and there's a family law case, typically, I think one of the lawyers is going to bring a motion to have all those actions brought together because it's really the same parties involved. And there's oppression remedy that sometimes has been taken advantage of the minority shareholder or the spouse that's ousted. But when I have a client come in who's a 50% shareholder on paper, but not an active partner, I frequently will say to them, what's your objective? Because do you really want to be partners with your former spouse in business going forward, where they get to decide what dividends, if any, are going to be paid to your shares because you're not working there? And the answer is going to be, well, they're not going to give you any dividends. Mm-hmm. They'll give themselves a bigger salary. Do you want to be fighting with them permanently on a go-forward basis? Then the second issue is, do you want to try and take over the business because do you have the skills or abilities to take over a business? Most of the time, the answer is absolutely not. So the practical reality becomes either an equalization payment that's going to cover the value of the business, or if the business goes up post-separation and you're joint owners, have a buyout. That's the practical reality. And there's case law under oppression, which actually has forced a buyout.
Yeah. And just on that point, I mean, there's always the legal analysis, but also the practical reality. And that's where we often get into the more meaningful discussions. Because I've had situations like this where the husband and wife are essentially playing a game of chicken. You know, they're working together, they're in the same office, they see each other day to day, they hate it. But the husband, assuming that the husband is the owner for a moment, the husband doesn't want to fire the wife because then there's a severance obligation. The wife doesn't want to quit because then she gets nothing. And so they end up playing a game of chicken. and seeing who can deal with it longer. And that's where it often becomes this practical discussion of, okay, it's not just an employment issue. It's an employment issue, a family issue, maybe a corporate issue as well. We've got to come up with some sort of global resolution. So often the law says one thing, but the practical reality is going to guide the parties as to how to resolve it properly so they can move on.
Now, the other thing that's always fascinated me is when clients come to me, I generally say, if your spouse isn't in the business, and even if they are, don't put your spouse on as a shareholder because you don't want them as your partner, plain and simple. But then some people say to me, well, my spouse is a director and officer in my company. And I say, that's amazing. And the reason why I say that's amazing is when it's a client who's in a business that is notorious for not reporting all their revenue because they have large cash business, it's great when the former spouse is a director or officer, because if they try to report the business or their former spouse to CRA, they're taking them down with them. Mm-hmm. They have the equal motivation of a path of mutual destruction that keeps them honest. So it's an ironic situation that if you're in a dishonest business, you're actually better off with your spouse as a director and officer. But if you're honest in your reporting, you're better off not having her. Something you can't have a candid discussion with your accountants about when you're planning.
No, but that's a great scenario where, and you know, I see that a lot, not necessarily in spouses, but I often have people come in and they've just been let go and they're all upset and they want to do whatever they can to make the company pay. And they talk about all the skeletons in the closet that they know about. But the problem is if they were at a senior enough level, then like you said, if they're going to report it, they may have liability as well, and they're going to take themselves down as well. So it often, you know, people come in all, you know, hot and heavy and they want to do everything. But at the end of the day, you know, usually if you knew of something and didn't report it, you're not going to want to bring it out now because you're going to bring yourself down too.
That's right. And then you also have to ask yourself if you have a significant termination package that you're entitled to. If you take the company down, they may not have the ability to pay it to you.
Or they may just choose not to pay you. Even if it's ironclad that they owe it to you, they'll make you jump through all the hoops and bring a court action and force them to pay it. So yeah, in most cases, and this is why usually when someone calls our office and they want to come in to talk about their severance package, I usually make them wait at least 3 or 4 days because they need some time to calm down. And then they can think rationally and then we can have a reasonable discussion. When they come in right away, they just want to, you know, it's going to be a scorched earth approach, which doesn't benefit anybody.
No, I see the same thing in family law. When someone comes in and their spouse just told them the day before the marriage is over and they believe their former spouse was having an extramarital affair, they'll sit there and say, I don't care what this costs. I want this person to pay. I'll take it to the Supreme Court of Canada. It's not, I agree with you, it's not a healthy environment to be dealing with things. And you do need to caution that kind of person that this isn't a healthy way for you to spend your money, nor is it a good thing for your kids. So as much as you may want to punish your former spouse, you have to balance that with what's best for your children. And high conflict litigation is never the best thing for, typically speaking, anybody if people can get along and actually reach a resolution. I'm going to move on to another question that we got before the show, which was, my wife had a garnishment order delivered to my workplace because I missed a few child support payments. Now my boss is threatening to fire me. Kenny.
And sir, for some reason, I didn't hear the first part of that. I heard starting with missed a few child support payments.
Okay, so the spouse missed a few child support payments, and now the former spouse has garnished his pay for their support.
Oh, I see. Okay.
And they're worried they're going to get fired because the employer's mad about having to deal with the garnishment.
Right. So here's the thing. I mean, theoretically, no, you can't be fired because you've been served with some sort of garnishment order or because you owe child support. You can't be fired for that. But the reality in Canada is, in most jobs, unless you're either unionized or a federal public employee, you can be let go at any time for any reason or no reason at all, as long as you're given either notice or severance. And we can talk another half hour about how you assess that. But the bottom line is there is no job security in Canada unless you're unionized or a member of the federal public sector. So you could be let go in that situation. And then the onus is going to fall to you to prove that you were fired because of the fact that this garnishment order was put in place. And at that point, you'll have to assess the pros and cons. Is it worth it for you to bring a claim, spend time, spend money, hopefully prove your case? But what are you going to get out of it at the end of the day? You know, the reality is you'll get your severance regardless, and you may get some additional compensation for bad faith or punitive damages. But, and this is again where you see the legal and the practical, and they're not always the same. legally, you probably have a right to fight it if you are fired. Practically, it may not be worth it unless we're talking about a long-serving employee with a substantial income, and you can prove that the reason for dismissal was because of this garnishment order.
Now, I've had many clients over the years, and I should take a step back. In Ontario, if you go to court and a judge makes a court order for support, the support payors pay will be garnished. It's just the way it is, unless the two sides agree not to. Right. If it's pursuant to an agreement, then one side can choose to take a positive step to cause the garnishment. So I usually start with saying to my clients that the first issue is it's a common thing in Ontario. Lots of employers see garnishments for support, and that the employer may not be offended by it. But if you really believe that that's going to happen, then you go to the other lawyer and you say to them, we have an employer that we perceive to be erratic. You may cause my client to lose their job if you force the garnishment issue. Well, then it's a question of what the recipient spouse is going to believe. Because if the recipient spouse has been married to them long enough and knows the employer is a wingnut, they may not want to take that risk and may agree with you not to have it. But by the same token, the payor has to be smart enough, pay on time, don't chance your fate and by not paying on time. You know, it's pretty simple to pay on time. You arrange with your bank to pay, or you write post-dated checks.
Yeah, it's pretty simple. And from the employer perspective, it's pretty easy and pretty simple to impose a garnishment or implement a garnishment order. So it shouldn't be a big deal. And I've had it occasionally over the years where employers have called me and said, we just got this order. What do we do? Or, do we have to keep this guy? And usually what I say is exactly what you just said. This is not unusual. It should not be a big deal. If you're working with any payroll company, they know how to do this. It's not a problem. So it shouldn't even be an issue of somebody losing their job. But like you said, if both parties know that the employer is like that, then they should have that candid conversation and hopefully avoid the need for the order. And then, like you said, just pay on time and it shouldn't be an issue.
And ultimately, you have to remember, even when parties are divorced, they're usually aligned when there's support being paid to keep the support payor working, because it's in the best interest of the recipient for the support payor to go to work and earn the money. So it's a simple thing I believe in. Now, I see that we got another question on Twitter, and that question had to deal with a couple that met at work and are now thinking about divorce, and they're concerned that their employer may force either one or both of them to quit.
Yeah, okay, a whole bunch of thoughts. One is you can't be forced to quit. That's called termination. So that's, I guess, the first point. But I guess taking a step back, I mean, I've had a lot of employer clients over the years who want to have their non-fraternization policies, non-relationship policies. They want to have a policy which says, thou shalt not have a relationship with anybody else at work. And I always tell our clients, you can't do it. First of all, from a practical perspective, you're never going to be able to enforce that. The reality is most of us meet most of our friends and contacts at work, and a lot of relationships come out of work. There's nothing wrong with having a relationship with somebody at work. The only time it becomes a problem is when there's a conflict of interest. So you should never have a supervisor and their subordinate in a relationship. Or even two people in the same department can cause issues. There might be perceptions of favoritism, etc. So I encourage our clients to have, strong conflict of interest policies, which say that if there is a conflict of interest, such as a personal relationship, it must be disclosed. Now, here's where it can lead to termination. I've seen this happen, and there's case law on this, where two employees are involved in a personal relationship, and the employees don't disclose it despite the existence of a policy. And the employer confronts them and says, we have reason to believe you're involved in a relationship with your subordinate. If they deny it, that's dishonesty. Now you may have cause to fire them for dishonesty and for conflict of interest, not because they had the relationship, but because of all the other elements of the situation. But in this situation, I mean, first of all, I can't imagine why, if they were together, working together while they were married, now they're getting divorced, I don't see why that the employer at that point would need to get rid of one or the other of them. But if there's ever a situation where you have two people in a relationship, it's causing an issue at work, you may have cause to fire them if they breach a policy, but otherwise you just need to find a way to separate them and eliminate the issue, not eliminate one of the people.
I think there's the practicality of it. Number one, in my own personal experience, when I was separated before I moved out of my home, it's an awful place to be living in the same home with your former spouse. It was once a happy place. It's not anymore. To then have to add the dynamic of going to work and being in the same setting with that former spouse. So now you're at home with them, you're at work with them, you don't want to be around them. I would anticipate one or both of them are probably going to be updating their resume and looking for work because they just want out of that. And if they're not doing that, knowing the way people usually behave, it would not shock me if one or both of them start behaving in such a way at the office that would create a dynamic in a situation that they're going to be getting warnings, and that their work will be suffering, and they will be getting warnings. And one or both could be terminated, not because of the divorce, but because of the way they behave as a result of the divorce.
And you said that perfectly. So you're not terminating them because of divorce. And I actually went through this with a client a little while ago, and that's exactly what happened. Two people going through divorce in the same small office. And actually, in that case, one of them was trying to be professional. The other one was clearly not, caused all sorts of issues. And I helped our client go through the process, and they issued warnings and made it very clear if it didn't change, then she'd be let go. And it didn't change. And ultimately, she was fired. Again, not because she was divorced, because of all of her other misconduct. So that might be what happens. And the other way to deal with it from an employer perspective, depending on the size and the nature of your organization, if you can transfer one of them to a different department, different office, different shift, whatever, that might be a way to accommodate the issue. Otherwise, if there is misconduct, then it's like any other kind of misconduct. You've got to engage in progressive discipline. And ultimately, if that doesn't get better, then you can fire one. You don't force someone to quit, but you can fire them.
So it's the practical reality of the dynamics. It's a question, I think, partly how big the company is, how much interaction they're going to have, lots of issues like that. We have another question that we have, which is, and this came in from a text message. I am going through a nasty divorce, and I have had to miss a fair amount of time at work for court appearances, meetings with my lawyer, etc. I tried to make up the time, but I'm worried I'm going to get fired.
Yeah, this is a tough one, and of course it happens all the time. So I mean, the reality, of course, is the employment agreement is at its fundamental basis. It's an agreement that the individual will come to work and do their job, and they will be paid. And when someone is not coming to work, then that becomes an issue. And contrary to popular belief, there is actually no statutory entitlement to things like sick days, although that's going to change with our liberal government's introduction of amendments to the Employment Standards Act as of January 1. But up until now, there is no statutory right to sick days, and certainly not paid sick days, although again, you'll get two as of 2018. But the reality is, of course, we all know people get sick, people have appointments, people have deaths in the family, people have court appointments, and as an employer, you need to be reasonable, but you need to set the expectations, and that can be giving fair warning. So if the person asking the question knows they're going to miss work, you can't just be texting your boss at 9 o'clock that morning saying, oh, by the way, I'm not going to be in today. If they knew about the court date, they should have given them ample warning. Most employers have a certain number of sick days or personal days, which you can use for almost anything. But if it becomes excessive, then at some point an employer can start to engage in progressive discipline and say, whatever the reason, we can't accommodate this any further. We have work to be done. It's becoming, we can't rely upon you to be here and do it. So you may face a situation where your job is at risk. Realistically, I've worked with a number of clients who are going through this. There's going to be a whole lot of activity for a short period of time. And then you may have sporadic court appearances or meetings with a lawyer. Hopefully you can do those outside of your working hours. In almost every case I've been involved with, it was a short-term issue and then it went away. So you just need to be upfront with your employer. Let them know what's going on. Give them a sense of when and how often you're going to miss work. Like you've said in your question, try to make up the time you miss and work with them to make sure work is not being dropped or falling through the cracks. And then it should not be an issue. If you're let go, you're always entitled to severance, and you could try to argue that this was a dismissal based upon family status, although frankly, I think that's going to be a stretch because it wasn't family status, it was absenteeism that caused it.
Well, you never know with what a court or an administrative tribunal may end up doing with a decision, but it also boils down to, from the employer's perspective, it may create some anger and discontent in the workplace with employees if they see the reason as the termination because you're being unreasonable by firing someone because they had a court appearance for a family law matter. And that's going to be in the back of the employer's mind as well.
Yeah,
That's what I would think as an employer.
and it cuts both ways, though. Sometimes you'll have, the rest of the office is getting upset because they perceive someone as being given preferential treatment. She's missing all this work time. We're picking up the slack. So
Absolutely.
It can cut both ways.
Absolutely.
But as an employer, that's your job to manage that.
Now, I have one more question, and we only have a few more minutes left. My husband and I are currently separated. We want to obtain a divorce. We are currently living under the same roof, and I understand you need to live separate and apart for 1 year before the court will grant me a divorce. However, my ex-husband and I are battling about who gets to take our son for outings on the weekends. Can we still be considered to be separate and apart if we take our son together? So this is really a question for me, Stuart.
I'll defer to you on this one.
The idea of living separate and apart is based on when there is no reasonable prospect of resumption of cohabitation. So technically, you can take your child to an outing together. However, you may face the argument at a later date that this was evidence of an attempted reconciliation. So if you really want to have best practices, I would send an email or text to my spouse saying, I'm not crazy about spending time with you, but I know that our children would love it if we both took them to the zoo together on Saturday. So I'm willing to do that for the benefit of our children, but please don't get the wrong idea. My view is we're still separated. Nothing is changing. That's the best practice, but there's also the practical reality. Sometimes people are stuck in a home for a year or two. So you may be taking your child with your former spouse together to the zoo, and on a weekend, and on the Monday, your lawyers are busy sending emails back and forth to one another about your separation. Well, in that case, it's pretty obvious you're still separated. It's more when you're in the early stages, you haven't told anyone, you haven't acted upon it, and maybe the two of you and only the two of you know that you're separated. And even then, frequently people play along for the sake of the kids for a certain period of time. In that scenario, email, text message, etc. We have 3 minutes left. And I thought one of the interesting issues, or 2 minutes now, is what's been in the news has been Harvey Weinstein and the fact he's going through a divorce as a result of his wrongdoings in Hollywood, or alleged wrongdoings. And he's been terminated from his employer. And that's a great case as an illustration of the cross-section of family law and employment law. And from your perspective, Stuart, how would you see that from an employment law perspective if it was here in Ontario?
Well, I've been talking about harassment and sexual harassment in the workplace for years. And, when the Jan Gomeshi scandal broke a few years ago, it became, part of the media focus for many years, which was great because people are now much more aware of their rights. They're aware that if they're at work, they don't have to put up with harassment. And employers are much more aware that they can't condone it or allow it to go on. The reality is, and I did a blog post on this a few days ago talking about the Weinstein matter, there are still a lot of businesses that see this as a cost of doing business, and they are prepared to deal with the potential liabilities, potential risks, potential fallout, because they want their star, whether it's Jan Gomeshi, Harvey Weinstein, the owner of the company, et cetera, they will allow it. And everybody knows that there is harassment and very inappropriate conduct going on, but because of the value that the company gets from the harasser, they allow it to continue until the price becomes so high that it's not worth it. And that's basically what happened with Harvey Weinstein. It became, they became a media focus for all the wrong reasons. Now you ditch the guy, even though realistically, they probably knew a lot of this long beforehand. But before it became a public story, it was worth keeping him. So from an employment perspective in Ontario, after Jan Gomeshi, our Liberal government introduced a number of pieces of legislation to deal with harassment, and among other things, created an absolute mandatory investigation if employers are aware of harassment or sexual harassment. So if this happened in Ontario and they didn't investigate, they would have even more liability than they would have had a few years ago. But either way, you have a duty to provide a safe work environment, which includes being free from harassment. So in Ontario and Canada, employers are going to face a lot of liability if they allow this type of thing to go on. The reality is, though, it still happens.
See, and from a family law perspective, I'd also be looking at it saying, well, if the harassment allegations came out just before the separation, he has shares in the Weinstein company. How does that impact the value of his shares? Because they have to be valued as at the date of separation. How do you value all of the potential litigation that he's facing? Because clearly, if I'm acting for Mr. Weinstein, I'm going to be saying there's significant contingent liabilities for all of these lawsuits that I'm going to be facing. And it may seem ironic, but Mrs. Weinstein, in a sense, may end up having to indirectly, if she was here through the equalization process, losing out on half of the legal fees and the settlement costs of all of that litigation. So indirectly, it does still affect her both on a personal level and a financial level. Now, I see that we're over time right now. So, Stuart, I wanted to thank you for coming on the show. It was truly a pleasure having you.
Yeah, thanks for having me. It was a lot of fun, so much so that I may as well start my own online show and talk about employment law issues.
And for anyone interested, I hope you'll have me on the show.
I would be happy to.
And for anyone interested in following Stuart on social media, you can follow him on Twitter at Rudner Law or on Facebook at Rudner Law. And the next Ask Andrew show is November 16th at 1 p.m. If anyone has a request for a topic, feel free to email us at info@Feldstein Family Law or message us here on Facebook. And thank you for watching and have a fabulous day.